Welcome to Aging Insight with your host, John Ross and Lisa Schollmeyer. This program is made possible by
Welcome everyone to Aging Insight. I'm Lisa Schollmeyer and I'm here with John Ross. We are elder law attorneys, and Aging Insight is the program where we bring you information that if you are a retiree or a senior, hope to be one someday, we hope the information we share with you on Aging Insight is helpful.
Yeah, we just try to bring all kinds of different aspects of information, particularly when it comes to health, housing, finance, legal issues that relate to as you're transitioning through those later years and then ultimately passing down property onto your beneficiaries. There's just so many little spots where you can mess something up purely unintentionally just based on your lack of knowledge. And so that's why we show up here.
All right. And John, you just mentioned that we often address issues that deal with health, housing, financial, and legal. And today, our topic is going to cover housing, financial, and legal all in the same topic.
Yeah, that's a lot of these, there's a lot of overlap in these different topics. And this is one of those that has been a problem for a long time. What we wanted to do was talk about some of the more recent solutions to this problem that have been passed in both Texas and Arkansas, so that and many other states.
Yeah, and what we're talking about today is something that many people refer to as heir property. And John, that's a hard word for me to say. I don't mean hair property,
right?
Which you may be fighting a battle on, I don't know. But I'm talking about heir property. And this is property that may have been passed down through your family, maybe land that your great-great-grandparents acquired when they staked a claim in Texas or Arkansas. And perhaps this land has been passed down through the family tree. And here we are in the new millennia in 2019, and it is a mess. It's the ownership is in question. But a lot of people in shorthand refer to this type of inherited property where maybe the title hasn't exactly been cleaned up in years, but they refer to it as heir property, and it can be a big problem. That's what we're going to talk about today.
That's right. And what Lisa's talking about, this property that's been in the family for a long time and past, that's where the root of this problem has really seen most of the litigation around.
Yes.
However, I will say that we deal with this on almost a daily basis from a very simple standpoint, and that's where, say, mom passes away and she had a house and the house passes equally to the two kids.
Okay.
We now have what's referred to legally as undivided joint ownership.
Okay, so the two kids, they each have a perfect right to the entire property.
That's right.
But they just own half of it.
That's right. And they don't want to be roommates.
Right, no.
And inevitably, whether you're talking about having these two people that own a house, or some of the ones we've seen where there's literally hundreds of different owners of a single piece of property, each having very small fractional interests.
Mm-hmm.
Either way, whether you got two people or 200 people, when one or more of those joint owners want something different than the rest of the joint owners,
right,
this becomes a problem. And this, again, it's been a problem for a long time. It's also been a problem that some people, some unscrupulous types,
yes,
have taken advantage of.
Yeah.
So going back, you would see, particularly in the South, where you would have property that has passed through the generations. In many cases, maybe grandma and granddad had that property. They had 8 kids. So when they died, that property was owned by 8 children. Each of those 8 children had 8 children, and each of those 8 children had 8 children. And so, you've got a whole bunch of people that have these little small fractional interests of this, say, 40 acres. Now, one particular share of that, not very valuable, but the 40 acres itself, often quite valuable because it's got things like hardwood timber and things like that that are mineral rights that could be very valuable. Well, you would have these unscrupulous folks, and they would go and they would research and they would find property like this that has all these different owners. They would buy one of the owner's little tiny shares, maybe that 1/100th interest for nothing, right? You get called out of the blue and somebody says, hey, did you know you own a 1/100th interest in a piece of property? And I'll give you a couple of $100 for it right now. Well, you're thinking, hey, that sounds fine. So this person would buy this small interest. Then they would file something called a suit for partition. Basically, this is the kind of lawsuit where when you've got joint owners, one person files and says, I want my piece out of it. Well, when you file that, the court only has really two options. Try to divide the property up, which when you've got 100 different owners on 40 acres is basically impossible. Or historically, the court's only real option was then to do a public sale. And Lisa, you know what would happen? They'd sell this property on the courthouse steps.
Right.
Public auction.
Yeah, they'd post a notice and they'd sell it at the public auction.
That's right. And these are not well publicized.
No.
And so very few people show up. In fact, in many cases, the only person that would show up for that public auction would be the same person that bought that little fractional interest.
You know, it's almost like they had a plan all along to purchase that fractional interest so that they could be called an owner of that property, and then avail themselves of the process in the court system where they could, as an owner, request that property to be sold. And of course, they're the only buyer that shows up at the public auction sale. So now the person who bought that teeny tiny fractional interest for a couple $100 ends up with the whole 40 acres for pennies on the dollar.
That's right. You know, maybe they're the highest bidder on that piece of property for $10,000. But you know, 40 acres worth of standing timber, that 40 acres might be worth $2,000 or $3,000 an acre.
Right.
You know, that's a $100,000 piece of property that they just bought for $10,000 plus the $500 they paid the little tiny owner. And all of the other owners, all the other 100 people that own this, they each get to split that $10,000.
Right.
So they all basically get nothing. This person gets the whole pot for virtually nothing, and then can turn around and cut all of that timber off and make a hefty profit off of this deal.
Yeah, so this type of abuse has been going on for, a couple of centuries, John. I mean, because
this is not new.
Yeah, there was really no good solution to how do you divide joint owners if they don't want to be joint owners together. So for the rest of the show today, we're going to talk about some developments in the law. We have some new laws, John.
We do. We have some new laws.
And that's why you watch Aging Insight. So we can talk about how to divide heir property and how to get joint owners, unlinked from one another, and hopefully maybe still preserve that family property. So we'll be right back.
Lone Star Truck Group is now hiring service technicians. We also have career opportunities in every department. With 23 locations across the South, work where you want. The best product lines in state-of-the-art facilities. Work with the best employees, receiving great benefits, competitive wages, and a safe, clean work environment. Receive ongoing product training for continuous career development. Contact Lone Star Truck Group today and recruit it at LoneStarTruckGroup.com.
Welcome back to Aging Insight, everybody. I'm John Ross here with Lisa Scholmeyer, and today we're talking about heir property, and that's H-E-I-R.
That's right.
Heir.
E before I in that situation.
That's right. We're talking about heir property, but the situation where two or more people have an undivided interest in inherited property. This could be something as simple as, their parents have passed away and this is passed to the brother and sister. Or it could be something where there was this family land that was owned in the 1800s. It's never been divided, and over the years, as family members have been born and grew up and had kids and passed away, the interests have passed and passed and passed until in some cases you have hundreds of owners of one single property. And before the break, we talked about how there really has not been any good solution to this. At least I can't tell you how many times over the years I've had the kids come in and they'll say, well, John, you did a will or you did a ladybird deed or something like that for mom. She's passed. The house has passed to me and the brother. Mm-hmm. We appreciate all of that. It was nice and easy. Everything passed automatically. It's great. The problem is now my brother, he wants to keep the house and maybe use it as a rental property. And I don't want to get into the rental real estate business. Right. I just want to sell this thing and take my half of the money and go home.
Yeah, so then you have owners with two different ideas about what to do with this property. And before, if one owner wanted to sell but the other owner didn't, then we really were at an impasse, and the only solution was to go to court. And John, as we say all the time, if you have to walk into the courthouse to get something resolved, you really already lost, even if you win. So this has been an issue. So this year, we have had a new law that has passed that addresses heirship property. Now, this law has been in the making for a number of years. This is something called the Uniform Heirship Property Act, where deep thinkers in the law have known about this problem in dealing with joint owners and heir property, and have crafted a proposed set of laws to address it. Well, now Texas and Arkansas have adopted these provisions, which changes how families and courts are able to deal with heir property. And John, one of the problems with the old law was that really, if the court could not divide the property among the owners, the only solution was to sell it publicly. Any stranger could, whoever the high bidder was, got the property.
That's right.
And so you had lots of families where this legacy of family property ended up getting sold outside the family because of these very harsh provisions. So that was really one of the reasons for the passing of this new heirship law, was to maybe give the families a chance to preserve their property.
That's right. If somebody wanted to keep it, this was a way to let them keep it. And if not, then at least let it be sold for fair market value without somebody who is just basically manipulating the system to buy up property cheap. And so the Uniform Partition of Heir Property Act was passed, and it's now been passed in about 19 different states, almost entirely across the South, where this has been a big problem over the years. And essentially it sets up kind of a scheme here, a way
I like the term framework.
Yeah, well,
scheme sounds a
framework,
little
scheme,
framework,
whatever you want to call it.
Yes.
But a method of addressing this issue. And basically it all starts out with somebody wanting out. And so when you've got one of the owners that wants out, they now can file it under this Uniform Partition of Heir Property Act. They can file in the court, and the first thing the court has to do is appoint an independent appraiser appointed by the court to go out and determine what that fair market value really is. And this is going to be the kind of the guidepost now for what to do with this property. Now we know actually what it's worth. in those previous cases, like the example we talked about in the first segment, the value of the property was really irrelevant. It was just that one person wanted out, so they filed suit, and hey, it gets sold in the public auction for whatever it can bring. Now we have this directive that we need to get the fair market value assessed, and then everything beyond that is with the goal of trying to get that fair market value. So they're going to start out, they're going to file this, the court gets the fair market value appraisal, and then, that's where, Lisa, we get all the other joint owners involved.
Yes.
Everybody's got to be notified.
Yes.
And anybody that wants to buy this now, that's one of those joint owners, they have the option of buying it for that fair market value.
Well, and this is great because this makes sure that if there's someone in the family that is capable and is willing to buy the property at fair market value, then they can, and it can stay in the family. But John, between the old law about heir property and this new Uniform Partition Act, one of the common problems that still exist between the two laws is finding those heirs.
That's true.
That, there's no, when your example before, 100 years ago, large families were very typical. And when you start with a large family 100 years ago, move 100 years forward, and even if those grandparents had fewer children, we're still often talking about 40, 50, 60 heirs, often spread all over the country.
That's right. And determining each person's interest can be quite difficult because, you have to look at every person that had an interest. Mm-hmm. Then look at what happened to their estate when they passed. Mm-hmm. You can't just assume, well, Uncle Smith died and he had 2 kids, so everything went to his 2 kids. Yeah. Did he have a wife? Did he have a will that left out a kid to where he didn't want anything going to one? So the problem of identifying and notifying all the heirs, still a problem. That's still a problem. And it's an expensive problem. Yes, it is. Because you do have to figure out all of this. And again, if it's you and your brother, no big deal, right? We know who the 2 people are. But in these others, it really can still be a very expensive process. That being said, with the advent of online genealogy research, and things like that, it has somewhat simplified the process. It has. So once we've identified all of these heirs and given them notice, now remember, the court has already had an appraisal, so the court knows what the fair market value of this property is. So all of these heirs are notified, and the court grants an opportunity for any of those heirs to purchase the property outright at fair market value. This ensures that the other relatives that maybe are not interested in buying the property, or perhaps simply just don't have the means to do so, that they are fairly compensated for their amount of their interest. Now, one of the catches to this, however, is that whichever of the joint owners of this property files with the court to partition under this new law, that particular joint owner cannot purchase the property. And now this is to address that issue where an owner would come in, ask the court to sell, and then be standing there ready to buy as soon as the court opened it for sale. This is to make sure that if a joint owner doesn't want the property and they just want the money, yes, they can petition to sell. They're not interested in buying, but the court will make sure that they get reimbursed for their value of the property. Now, John, if nobody can purchase the property or wants to purchase the property, the law still addresses those options as well. And I guess we'll take our break and we'll come back and talk about some of the wrapping up that the court can do with this heirship property. We'll be right back.
Lone Star Truck Group is now hiring service technicians. We also have career opportunities in every department. With 23 locations across the South, work where you want. The best product lines in state-of-the-art facilities. Work with the best employees, receiving great benefits, competitive wages, and a safe, clean work environment. Receive ongoing product training for continuous career development. Contact Lone Star Truck Group today and recruiting at LoneStarTruckGroup.com.
Welcome back, everyone, to Aging Insight. I'm Lisa Scholmeyer here with John Ross, and today we're talking about something in our area we often refer to as heirship property, although that's not really a technical term under the law.
When I first moved to Texarkana and I had some clients come in and I was asking them about what they had. Do you own a home? Do you have retirement accounts? I asked, do you have any other real estate? And they said, well, yeah, we've got some heir property.
Yes.
And I mean, I went to law school.
They never mentioned heir property in law school.
I took property class,
Yeah.
and I had never heard of this word, but I guess now that we actually have a law that's titled the Uniform Partition of Heir Property Act, I guess it's now actually a legal term.
Yeah, I guess so. So, yeah, well, that just goes to show how big and common of a problem dealing with heir property has been. So we've talked about the old law was bad. It often deprived families of the ability to hold on to their property. It often provided the opportunity for schemers to come in and get the property for next to nothing. And so now we have a new law which gives families a little more power to deal with this heirship property. So John, in our last segment, we talked about how someone could ask the court's going to get the property appraised, and then a family member can in fact step up, and it could be a couple family members if they want to go in together. I mean, there's no issue there, but it does give families an ability to buy the property. But now let's talk about what happens if there's no family members that are interested in this property, or that just simply don't have the wherewithal to purchase the property at the fair market value that the court has determined.
Right. So historically, this was the part where the court would just sell it on the courthouse steps. Public auction, it gets for whatever it gets and everybody goes away. Now the court is being instructed by this new law to sell it for fair market value. And so before they could do something like a public auction or anything like that, their first job is to hire a real estate agent and sell it just like you would sell your own house if you were ready to move on. Get out there, put it on the open market, advertise it for that fair market value, open to the public, and see if anybody is willing to pay for it at that appraised value. And then if that doesn't work, the court can look at other options. But even then, those other options, the court has to make a determination, an actual legal ruling, that the court expects these other options, like, for example, a sealed bid auction, or even the old courthouse step auction, but the court has to make a determination that they anticipate this being the way to get the most money off of the property. Maybe the just trying to sell it hadn't worked, maybe nobody was buying it, or maybe there's some other issue with the property that's been discovered now. But the whole point here is to try to get as close to the fair market value as they possibly can, ultimately to protect all of those other undivided joint owners from, somebody just swooping in and effectively stealing the property out from under them. And I think this is a good law, Lisa. I like it. I now have a tool when that brother or sister comes in and says, I want out of this property. I just want it sold.
Yeah, because oftentimes that brother or sister that comes in that doesn't want to be a joint owner in a property, all they want to be is bought out.
That's right.
And often their other sibling who maybe wants to use that property for rental, or maybe I've had this happen a lot, where a brother and sister own the property, but brother has let his adult child move into the property, and that adult child's living there rent free. And so the sibling, the sister, is like, hey, wait a minute, I don't want to be a part of this. If I'm not getting rent, I just want to be bought out, and then my brother can do whatever he likes with the property. Well, John, oftentimes that's all that joint owner wants to begin with. It's just to be bought out and be done with it. So this law does give that tool without the risk that the property will be sold to a stranger.
Right.
And without the risk that the property will be sold for well under fair market value, so that, in the past, I could say, well, sister, we can go to the court and we can ask the court to partition by sale, but, the buyer may only bid half the value of the property.
Right.
And so you only get a quarter of what, and it was just a mess. And the options weren't attractive. So now we have some good options. But John, I would say the best option of all in dealing with heirship property is for you to plan for it. So often we have seniors that are making their wills or their estate plans, and they want to treat all the children equally.
That's right.
And so they leave the old place in Foreman, Arkansas equally to their 2 children. But yet one child lives in Seattle, Washington, will never come back to Foreman, Arkansas, has no interest in this property whatsoever. But the parent is so intent on making everything equal that they kind of ignore the reality.
That's right.
And they divide the property equally among these kids. And then we end up with an heirship problem.
That's right. And you can solve this in a number of different ways. One, for example, just surveying property off, and so each person gets their own individual share. You can build into your estate planning things like a right of first refusal, an option to purchase, and other things like that essentially almost mirror what this Uniform Partition of Heir Property Act says, but doing it in a way where maybe they don't have to go through that whole court process to get there, that they can do that through the administration of the estate. Maybe the executor has these powers, things like that. So you can plan for it and it'll be even better. But for those of you who are already sitting there, you now have a solution. It's a pretty good one. So we're coming up to the end of the show. We appreciate you sticking with us through this edition of Aging Insight. And check out our magazine out there where you might find it. And otherwise, we will see you next week.
All right. Bye-bye.